really pleased to have Taz Rajan with us here this morning. She's with Bromwich+Smith, and I've known her through a number of different networking groups and stuff, and she's just awesome. She's taught me a lot about the consumer proposal and bankruptcy field, and I thought this was a really great intro or some information for us. While I know that isn't our typical niche of client, we all know somebody, maybe a client, who has had family members that are going through some difficult times. And kind of coincidentally, now, of course, with COVID, this is going to add some additional strain onto people's finances. So she's a wealth of information. I'm going to pass it over to her, but I would ask that everybody just go onto mute, just so that we can cut down the background noise and place attention onto the presentation. And then I think there's some time at the end that Taz has arranged for some questions and answers. So with that, Taz, go ahead.
You bet. Thank you so much, Joanne, for the lovely introduction and for having me. Thank you all so much for being on the webinar today. I wish I could see you. I wish I was at your office bringing you yummy treats. So I definitely owe you some treats once this is, over and we kind of go back to whatever the new normal looks like. But thank you so much for having me. And I'm going to just jump right in. And definitely welcome your questions at the end. And feel free if you think you might forget your questions, just pop them into the chat. I will go into the chat once I'm done my presentation. I expect to be about 45 minutes, and then I'll leave 15 minutes for Q&A. So just wanted to talk about, a little bit about like, why are we even here? Why are we talking about this subject? And there's quite a bit of, quite a few stats on this page. I'm not going to go through each and every one. Sounds like somebody's maybe not on mute. Could I please request everyone to mute themselves? Thank you. I don't know how to do the mute all function on this one, guys, or else I totally would. So Bromwich+Smith, we recently did a survey, and it was just in March, actually, to see sort of the effects of COVID. And so, in that survey, we found almost half of all households in Ontario, Alberta, and BC have experienced income reduction as a result of COVID. And then, kind of in each of the provinces, the hardest hits were like the major centers, so Calgary here in Alberta. And of those, what was really interesting is that 23% of people had kind of said they're not exactly sure what they're going to do. And this is why, we thought, Joanne and I thought that it was really important to have this session for you, because you are financial planners. I always look at a financial planner as sort of the quarterback of somebody's life, right? And then you've got your plays, you've got your tools, you've got all your different teammates, but you're the quarterback. And I think, if you haven't started to get the phone calls, you may start to get the phone calls and the emails, in the next coming weeks. But it's also a great opportunity for you as the financial planner to reach out to people. And I really wanted to equip you with some tools that I know for the most part, you're working on the wealth building side of things. You are going to start to run into some people that are maybe struggling with debt. And I just wanted to equip you with, how are you going to be able to help them? How are you going to be that quarterback? What's going to be the play that you're going to, kind of put forth to help your clients through this period? Just quickly, a little bit of my background as well. I was with Scotiabank for 5.5 years, various positions. And then I was a mortgage broker for 10 years. And then now I've been with Bromwich+Smith, licensed insolvency trustees, as the community engagement partner for coming up on 2 years. I'm going to talk a little bit about Bromwich+Smith near the end of the presentation. I kind of want to get to the meat of the stuff right away, okay? So dealing with debt, let's have a look at what are the options that are available for you, your clients, as we're trying to manage and deal with our debt, okay? So there's the orderly payment of debt, there's credit counseling or debt management, there's consumer proposal, bankruptcy, and there's the do nothing. And I'm going to go through each of these options in a little bit more detail so that, again, you've kind of got an idea of, what do these different options look like? How does it affect their credit? How would a client access this information? And kind of what are the pros and cons of each one? So let's start with the orderly payment of debt. The payment of debt, payment of debt program is only offered in certain provinces. So it's only in Alberta, Saskatchewan, and Nova Scotia. The rest of the country has kind of said, we really don't see a place for this program given the other options that are available. So with an ODP, you are actually paying back all of your creditors in full, 100% of what you owe them. Generally speaking, a student loan or CRA debt usually cannot be included in an orderly payment of debt. There is an interest on top of what you're paying back. It's kept at 5%. So really you're kind of paying back 105% of what you owe all of your lenders. And there's no what we call a stay of proceedings. A stay of proceedings is this legally binding act that stops creditor action. So it stops your creditors from being able to contact you, from garnishing your wages or any judgments, that kind of thing. And it does remain on your credit bureau. So the program itself is 4 years. And then the rating or the fact that you did some sort of a debt restructuring will remain on your credit report for 3 years after you've completed the program. So there's a quick overview of the orderly payment of debt. Here in Alberta, it's offered through a place called Money Mentors. They're a nonprofit organization, and it's administered through the government. The next option, you've probably all heard of, credit counseling or debt management programs. Many are not for profit. Not all of them are not for profit. So for example, the Credit Counseling Society, who we work very closely with, nonprofit nationwide. And then there's also Roman's Debt Solutions out of Edmonton. And they're not a non-profit, but they are one of the reputable debt management or debt restructuring companies that we partner with. So in these programs, again, you are paying back all of the money that you owe your creditors, and it's over a 5-year period. The interest rate is negotiated. It really depends on which agency you're working with and how the negotiations go. Again, there's no stay of proceedings, so there's no legally binding law in place that says that your creditors can't contact you once you've entered into one of these programs. And this will remain on your credit report for 2 years after you actually complete the program. And I'm sorry, I'm saying you, and I don't mean you as the financial planner, of course. I mean anyone that decides to take this option. So please excuse me as I say you. I probably will continue to do that, okay? Now, the key here is many will actually, there are some debt management programs that charge an upfront fee. So let's say in a situation where they kind of have looked at your situation and they go, yeah, you know what? This really is an insolvency and we're going to need to, set you up with a licensed insolvency trustee. There are quite a few out there that will charge, say, a $3,000 or $5,000 fee to sort of prepare your file and bring it over to a licensed insolvency trustee. And this is one thing that as financial planners, I really want you to be aware of. It is okay if a client decides that they want to pay fees for a certain program. The catch is a couple of things. A, if you came directly to licensed insolvency trustee, there isn't that upfront $2,000, $3,000 fee. The other thing is you should not be paying a fee continually to someone once you've entered into an insolvency program. And I'm going to go through what those programs are. So those are some things to really be mindful of and make sure that we inform our clients of. So I kind of alluded to it. Let's look at consumer proposal. A consumer proposal is a repayment plan to pay back a portion of your debts, and it's subject to creditor approval as well as your budget. So generally it's not 100%, and a common question that I'll hear is, is there sort of a magic number? Is it always, 20% of what I owe? Or, are you more likely to be able to, get everyone on board if we're paying back like 80% of what we owe? And there isn't a hard and fast rule. It's really very individualized to each person and what their situation is. It is federally legislative, so there are guidelines and rules in place for, what your income is, how many dependents you have. So it's really very, very individualized, but suffice to say, generally speaking, you're not paying back 100% of what you owe your creditors. In a consumer proposal, student loans and CRA debt can be included, usually can be included. There are some conditions that apply. When we get to the Q&A, if that's something you want me to talk about, we can talk about that in a little bit more detail. There is no interest in a consumer proposal, and there is that legal stay of proceedings, which protects the creditors from any legal action from, the debtor from any legal action from their creditors. So it stops the wage garnishee, it stops, the bank account garnishee, judgments, the letters, the threatening letters, the phone calls, all of that is stopped. All of that has to go through the trustee, and that is legally binding on the creditors. It's not an option for them. The individual must be able to make their monthly payments for a minimum of 3 years in a consumer proposal. And again, given the current pandemic, this is something that's a little bit fluid, and we're really working with clients to sort of help them through this process. And again, the creditors are playing fairly nice here. Your assets do not vest with the trustee in a consumer proposal. So when I get a little bit further down, we're going to look at some of the myths with consumer proposal and bankruptcy. And one of the myths is, oh my God, you're going to lose your house, your car, all your investments. And, definitely in a consumer proposal, those assets do not transfer or sit with your trustee. And then a consumer proposal does stay on your credit report for 3 years after you complete the program. And the program is, anywhere from 3 to 5 years. And then it does remain on your credit report for 3 years after you complete the program. So let's look at bankruptcy. That's the next option that we're looking at for what you can do if you are struggling with debt. So in a bankruptcy, the repayment can be as little as 0. So you're not paying anything back to any of your creditors. There is a basic administration fee for a first-time bankrupt, and that ranges between $1,611 to $1,800 over that 9-month period. So if you look at the 9-month, sort of monthly payments, it's between $179 and $200 a month. This is federally regulated and federally legislated, so it's not like, one trustee can charge, $2,200. The maximum is $1,800. Just at Bromwich+Smith, we've decided to go a little bit lower just to help our clients out. So we're at $1,611, but pretty much straight across the board, any licensed insolvency trustee will charge that $1,800, which is about $200 a month for 9 months. And so this is something I remember when I was in a place in my life where I was really struggling with debt, and Max was calling me, and I was in such a rough place. And so I said, oh my gosh, I'm not going to be able to pay this. I might have to declare bankruptcy. And she said to me, well, if you can't pay this, you can't afford to go bankrupt. And I just bawled my eyes out. So, there is a cost to the bankruptcy process as well. And again, that is federally legislated. And, most trustees will work with their clients to figure out a way to make this happen. The bankruptcy does provide that legal stay of proceedings. So again, this is where the client is protected from judgments, garnishee, that kind of thing, any action by their creditor. And the assets in this case do vest with the trustee. Now, that doesn't necessarily mean you lose everything. However, the trustee now comes into all of your assets and, kind of holds them in trust. And I'll talk about that in a little bit more detail as well. A bankruptcy does remain on your credit report for 6 years once you've been discharged. So, a first-time bankruptcy usually will go 9 months, and then it remains on your credit report for 6 years after that. Let's get into a little bit more detail. There's one more, right? There's the do nothing option as well. So in a do nothing option, if you're waiting, maybe you're sort of in this holding pattern, with kind of what's going on right now. And quite often when we're sort of in this crisis mode, it's almost like you're walking on thin ice and you hear a crack. And quite often what we'll do is we'll just sort of freeze. So the do nothing to me is that, where you just freeze on the ice and you're not ready to take a step forward or back. And in this case, you really do need to consider the risks involved with doing nothing, because I'm going to talk a little bit later about what your creditors' rights are. And they could be, they could garnish things, they could seize things. You're dealing with maybe collections agencies, phone calls, letters, threats, that kind of thing. Now, in some cases, there are some people who are considered judgment proof, which means they can actually do nothing and their creditors actually cannot go after them. So, that again is a very particular situation, and that you're only going to know if you're judgment proof if you actually speak to an expert in that field. So the do nothing, yourself without seeking, any guidance could lead to, it could be a risky proposition. If you've made a phone call and you've talked to an expert and they determine that you are judgment proof and advise you to do nothing, then that could actually be a viable option. So let's have a look at your creditors. What are their rights? And again, your client's creditors is what I mean here. So depending on the type of contract, and I'm going to speak specifically to Alberta, okay? So if it's a secured contract, so examples of secured, of course, you guys are in the industry, something like a car loan or a mortgage would be a secured credit. Your creditor can seize the security, they could sue the client, or they can actually do both, seize the security as well as sue the client. Now, in Alberta, as far as the car loan goes, they can only seize or sue, but in all of the other provinces, they can seize or sue or do both in a secured credit contract. Then we have a conditional sales contract. So the best example of that would be like those rent-to-own furniture companies. So in that case, it's a conditional contract, and they can either seize the items, they can sue you, but they cannot do both. They can do one or the other. So they could come in and pick up the sofas and the TV and all of that, and then it's over. Or they can say, you know what, that stuff has no value, you keep it, we're gonna sue you, but they can't do both. And then finally, there's the unsecured credit. And this is the area that we as licensed insolvency trustees, this is where we can actually help out. So this is where there's no good promise. So that would be your credit cards, line of credit that's not a secured line of credit, other utilities, that kind of thing. So they can either stop the service, they can begin collection process, and they could sue you for the debt, and they can actually do any combination of those things. So important to know, what your creditors can do. The other thing they can do, of course, is send letters of demand, threaten legal action. They could move it to a collection agency, and collections agencies are under no obligation to accept your payments. They can continue collection activities even after you've made your payments. So I've got a link here, and I can send these links over to Joanne after. But this is the Financial Consumer Agency of Canada, kind of saying, know your rights when it comes to collections. And this is a really important link to have for sure. So what happens if your creditors sue you, okay? The creditor needs to file a claim in the courthouse, and, the individual has up to 20 days to file a dispute. And this is really important to know. Most people, when we're in this situation, we often won't even open our mail. And it is important to open mail and to take some sort of action. You do have 20 days to dispute, which is great. If you can just go to court and dispute your situation, in some cases there have been, some positive things that have come out of that. But if there's no dispute, then a judgment is issued by the court. And then there's legal action that can be taken, including garnishing your wages, garnishing your bank account, and then, putting a lien on any property or seizing that property. So, if a creditor sues, I highly recommend, if you think you're going to be in that situation, open up that mail and, take action, right? So what about you? And by you, I do mean, of course, your clients or a debtor, someone who's owing money. What are your options, or what can you do? Okay. So we've kind of talked about like each of the options, but, again, rework their budget. And I think this is an area, of course, that you guys can help people out with. So really calculate, expenses. Can you increase, income? Can you decrease income? You know, what are the things you can do to sort of change that budget? I know a lot of people right now are seeing some savings actually with COVID, not having to maybe travel into work or not going out to eat, that sort of thing. Joanna and I were talking about Starbucks earlier. So, you know, maybe you haven't saved that much on coffees out, but you know, there are some savings that people might see in terms of reworking their budget. Another option is to refinance. And again, I'm talking to professionals. I'm not going to describe what a refinance is unless you need me to tell you, but I know that you're quite familiar with that. And then there's a consolidation loan as well. And this, you know, depending on the person's situation, this can be a slippery slope for someone if they're just borrowing to help get out of debt. So I think this is one that I know that you guys do a bang up job on really walking your clients through, you know, this consolidation loan and sort of, you know, how do we stay moving forward in the future? I know, again, like I'm the poster child for what not to do. So I, in my 20s, racked up a lot of debt. You know, you go to university, you get all these credit cards with like free t-shirts and free coffee mugs. And so I'd applied for everything and didn't realize I had to actually pay it all back. And you know, I did do a consolidation loan. I didn't have to close out any of my credit cards. And so again, being young and silly, I ended up racking up those credit cards again and having this consolidation loan to pay. And that can really start to snowball on someone. So again, you know, a consolidation loan is an option. You just want to be cautious in how you're using it and how you're setting yourself up for success going forward. There is the borrow from friends and family. And I think with that one too, there just has to be just so much due diligence done on that to really define repayment terms, have something in writing. Another thing that sometimes people will do, maybe they're applying for that consolidation loan and they'll have someone co-sign for them. So there's pros and cons of co-signing as well. I think a lot of people feel that being a co-signer is like, yeah, it's okay. You know, Joanne is good for it. I'm gonna co-sign. And what I'm really saying when I co-sign for Joanne is, hey, you know what? If Joanne doesn't pay for it, I'll pay for it. So it's really important to be very, very clear on what a cosign, you know, situation means. And, you know, if we're going to borrow from friends and family, again, to have that plan in place to get out of it, right? There is the opportunity to negotiate with creditors directly. And right now, given the pandemic, creditors are really coming to the plate, at least for now. I know for my mom, so she's elderly, her CIBC credit card called her to say, hey, we're just calling to check on you with this pandemic. You know, has it affected your income? Has it affected your ability to pay back your credit? So this, if at any time, this is definitely the best time to at least start with the negotiating with your creditors and keeping those lines of communication open. I would say they're more likely to work with you before you get into trouble, before you get into a position where they're you know, sending you to collections or a judgment or anything like that. They're a little less likely to work with you once you're there. So I would say, you know, when you start to see, whoa, I'm struggling to make my minimum payment, or, you know, I've just missed a payment, that is the time to negotiate with creditors. You don't want to wait too long for that. So I want to talk a little bit more in detail about bankruptcy, because this is the one I think that there's a lot of stigma attached to. So, you know, a personal bankruptcy is a legal process. It's regulated by the Bankruptcy Insolvency Act, or the Office of the Superintendent of Bankruptcy here in Canada. And it's basically to permit an honest but unfortunate debtor to get a discharge from their debts based on reasonable conditions. So I see it as like, you know, when you've made a promise to someone, I've promised to meet Joanne for lunch at noon. And now I've realized I am not going to be able to make it to that lunch. So I had a promise, and there, you know, it wasn't a prediction. I hadn't predicted that, you know, maybe God forbid I was going to get into a car accident on my way to meet her. So, you know, the promise was based on these terms, and there's been, you know, a change. I'm, you know, this honest friend who was going to meet my friend for lunch, but I'm in this unfortunate situation, and that's where a personal bankruptcy comes in. So bankruptcy is the last resort, but it's not the end of the world. And I really want to talk about this for sure. Again, in a bankruptcy situation, as I said, you do have that stay of proceedings. So it is that legal protection from your creditors. I'm just going to check. There's somebody that's not on mute. Okay. Let's see if I can get you and put you on mute. Bear with me here one moment. Right. Right. Just trying to find the person. Sorry, guys. I don't have a mute all. I'm really going to have to find that. Okay, I think I found you. Okay, perfect. So again, a bankruptcy has that stay of proceedings. It legally protects the debtor from their creditors being able to contact them or garnish their wages. First-time bankruptcy is a 9-month process with monthly income and expense reports. There are 2 mandatory counseling sessions in a bankruptcy situation, because one of the foundations of the Insolvency Acts is rehabilitation of the debtor. So rehabilitating people, in their financial situation, in their credit, in their debt situation. During the bankruptcy, any GST rebates, tax refunds for that year are automatically forwarded to your trustee. So the trustee kind of steps into your SIN number during a bankruptcy, and everything is directed to the trustee, and it is there to help them cover the administration fees. And also, if there's a dividend that needs to go back to your creditors, then that, goes to them. Because in a bankruptcy situation, you're saying, here's my unfortunate situation. I'm not going to be able to pay you back. I just don't have the funds. But then if you're coming into funds, then that belongs to, your creditors, or it can go to help offset the cost of the administration of the bankruptcy. The things that are exempt from that, though, are child tax benefit or universal child care benefit. Those do not go to the trustee. Those stay with the client, and they are meant for them to use, obviously, for their child. So they don't go back to paying the creditors or paying your trustee. Again, there's no fee for a consultation. I've kind of talked about the cost of a bankruptcy. It is that roughly $200 a month for 9 months. We can look at strategies to help someone out with that if they're in a situation that, they're not able to pay that $200. And then any other fees or surplus income are adjusted based on any GST rebates and any other monthly income of the person based on their income and their number of dependents. And that's really getting into some nitty-gritty, so I'm not going to go through that in too much detail. And if we need an extension of time to pay those fees, that can also be negotiated. So again, bankruptcy is the last resort, but it's not necessarily the end of the world. So I just wanted to talk a little bit about some myths along the lines of bankruptcy. So, people believe that all of their assets are going to go away, and there are certain assets that are exempt. So on this side here, exempt from bankruptcy. In Alberta, a single vehicle, you're able to keep that one vehicle as long as the equity is no more than $5,000. In terms of furniture and household goods, again, that is up to $4,000 per person that is declaring the bankruptcy. Clothing and personal effects is $4,000. Tools of the trade required to generate income. So let's say you're a painter, you need your truck, you need your steel toe boots, you need your painting gear. So up to $10,000 of that is not touched or not brought into the bankruptcy or held in trust by the trustee. Equity in your home up to $40,000 is okay. Like if you have $40,000 or less equity in your home, you would not be required to liquidate that. And then the big one for you as financial planners, life insurance policies that have a beneficiary who is either mother, father, spouse, or child. Those are totally protected under the Act, and all registered plans, our RSPs, our ESPs, pensions, RDSPs, those are all assets that do not vest with the trustee. When you declare a bankruptcy, they stay with you. So a lot of times when someone's in debt, one of the first things they'll look at is liquidating things like their RSPs. And that is something that we definitely advise people not to do. Now someone's asking in the chat whether that's only in the last 12 months. In Alberta, it's all registered products, even if it was in the last 12 months. It would need to be reviewed if it was in the last 12 months, but it is all exempt. In other provinces, you're correct. Anything that was in the last 12 months is subject to vesting with the trustee or having to play into your payments. And then there are certain debts that don't go away even in a bankruptcy situation, and that's really important to know as well. So if there's any sort of a fine or court order, if there's an award for damages by the court, alimony or child supports, you can see all these court-ordered things. Any debt that comes from theft or fraud, any property that was obtained under false pretenses. Student loans, if you have been a student in the last 7 years, then your student loan cannot be included in your bankruptcy. And then any dividend that would normally go to your creditor, had they been aware of the bankruptcy, also, would not go away in your bankruptcy. So it's really important to know that, there is a lot of protection under the Bankruptcy Act. There's a lot of assets that are exempt, but then there are certain debts that will not go away even in a bankruptcy situation. And I'm happy to share this slide deck, by the way, if that helps. So again, this is just, what are the exemptions again? So clothing and personal effects, $4,000, furniture, $4,000, automobile, $5,000, equity in a home up to $40,000, and then RSPs, life insurance policies, 100%, and then any tools of the trade, $10,000. And this is Alberta specific, okay? Okay, the other big thing when someone files into a bankruptcy, we really want to make sure that we are ensuring that that stay of proceedings is there to protect them. So we do often, suggest that someone open a brand new account with a brand new institution because the banks do have that right of offset. If you're owing money to your bank, they do have the right to go into that bank account and pull that money out, garnish it. So again, there's a great link here through the Financial Consumer Agency of Canada on knowing your banking rights that I highly recommend. It's one of the links that you have if you're having this conversation with your clients. So let's talk about the difference or similarities between a consumer proposal and a bankruptcy, because consumer proposal is, an option. It's such a great alternative to bankruptcy that is not really often talked about, and people aren't as knowledgeable about. So just wanted to share the differences or the commonalities between the two. So both are under the Office of the Superintendent of Bankruptcy. Both are federally regulated, and both can only be done through a licensed insolvency trustee. And it's really important to know that. Again, there are debt management companies out there that claim to do consumer proposals as an alternative to bankruptcy, and just know that they are actually taking that file over to a licensed insolvency trustee. They're sort of being this middleman, because the only way to do a consumer proposal is through a licensed insolvency trustee. So in the bankruptcy, you're required to make your payments to the trustee based on your household income and sort of what the guidelines are and what your budget is. You do need to come to 2 mandatory counseling meetings. You need to track your monthly income and expenses. You need to ensure that all your taxes are filed and up to date. You're going to assist your trustee in gathering documentation that is required. And in most cases, the discharge from bankruptcy will happen automatically 9 months from filing, as long as you've completed your obligations as the debtor or as the client. On the consumer proposal side of things, there's an agreement to pay a fixed dollar amount over a specific period of time to settle the debts. Again, you're attending 2 mandatory counseling sessions. In a consumer proposal situation, it's really interesting that this is why I said, it's really important that you can make your payments, because if 3 payments are missed, the consumer proposal is now annulled, and the client would have no choice but to declare bankruptcy. So it's really important to be very transparent with your trustee, very honest, and set up a payment plan that really truly is going to work with you. The nice thing with a consumer proposal, though, if your income goes up and you want to pay it off sooner, you can. And when all the requirements are fulfilled, a compliance certificate is issued. And the other big thing I wanted to share, in a consumer proposal, client can actually start rebuilding credit during their consumer proposal once they've signed into a consumer proposal, whereas in a bankruptcy situation, you would have to wait until discharge in order to rebuild credit. So we have some really great webinars on credit and sort of where your credit's at before you file into one of your programs with Bromwich+Smith. what happens during and what happens after. And I'm happy to share that link as well. But I know that that's what happens to your credit is a big question that comes up in the insolvency world. So I wanted to share that with you. And we're just going to talk about credit report in a little more detail here as well. So any type of consolidation repayment plan, like the orderly payment of debt or consumer proposal or credit counseling, those will show up on your credit report as a 7, an R7 rating. And again, I know you guys are familiar with credit reports, and they remain on the credit report for 3 years after you complete the program. So the total is usually 7 years. 7 years is the maximum, right? A first-time bankruptcy is going to stay on your credit report for 6 years after discharge. So a first-time bankruptcy is 9 months, and then it remains for 6 years after. So it's almost 7 years that it remains on your credit report, and it's an R9. So it is a slightly worse rating than a consumer proposal or an orderly payment of debt or credit counseling. Second-time bankruptcy, it's going to stay on your credit report for 14 years. And then just know that if someone has credit products that are placed into collections or in judgment, they're already at an R7, and it will remain on the credit report for 6 years as well. So really important to just be clear. I think a lot of times we just feel like, insolvency is this worst thing for our credit and we'll never be able to get out of it. And that's not in fact the truth. So just quickly want to touch on, I kind of did talk about it, unscrupulous players. Again, debt is a topic. I find Canadians are more open now to talk about, hey, we just got a raise or we just bought our new home. Like we're able to talk about our positive financial situations, but we're still not really openly talking about these negative things like, hey, my spouse and I are both working full time. We're bringing home a 6-figure income. And at the end of every month, we're still in the red. Like these are not the conversations we're generally having with our friends or with the professionals that we're working with. And so quite often I find people in that debt situation, 2 o'clock in the morning, they're on the internet. There are a lot of predatory lenders on the internet, and also in bricks and mortar. So, some of the key things I just want to say for you as professionals to warn your clients around is, if someone is pressuring you into signing something right now, that should be a red flag. If someone is charging you a large upfront fee or is saying that there's going to be balloon payments at the end, that's something to be concerned about. And if someone is saying they can put you through a consumer proposal and they're not a licensed insolvency trustee, you want to be concerned with that. And finally, it's totally fine. If someone decides to pay someone for financial coaching and that's an agreement that they have, that's totally above board. But then if you're going to sign into a consumer proposal or bankruptcy, those payments cannot continue. They cannot continue to be paid because you're telling all the other creditors that you're insolvent. And another pillar of the Insolvency Act is, the equal distribution of payments to all creditors. And so that's an unequal situation where you're sort of paying this person a continuing fee for financial coaching, but you're telling all your other creditors, I can't pay you. So those would be some key things to watch for as professionals. If your clients are talking to you about this, that they've kind of gone down this road, then, you definitely want to talk about those things. And again, if they're coming to you to liquidate anything registered or a life insurance policy that has a beneficiary, as I said, again, these are some things that are protected under the Insolvency Act, so important for you to know that as well. Okay, I know this is really hard to see on this screen, but I'm going to send this off to you. It's a summary chart of what I've talked about, the do nothing, orderly payment of debt, credit counseling, consumer proposal, and bankruptcy, and it just kind of goes through how do I access it, what are the costs and fees involved, what kind of debts are covered, what kind of asset protection is there? How long does it take? What's the impact on my credit report? And what happens if I default? So again, I will send this over to Joanne to share with you where you can actually see it. I wouldn't say it's really client friendly. This one I feel is more for us who are in the industry to just sort of keep things straight in our minds. So I'll talk a little bit about Bromwich+Smith now at the end. I'm hoping that I've certainly added value up until now. And I love this quote by Suze Orman, and she says, your self-worth is not determined by your net worth. And once you realize this, you will have financial freedom. And so our tagline is rebuild your worth, because we recognize that when we're juggling debt, we're struggling with debt, that's a hit to our net worth, but it does impact our self-worth. And we're all about working with people to help, with that financial well-being, and look at that 360-degree view of the whole person, and how do we rebuild their worth. Our purpose, I just wanted to share, I'm going to go through the key points: that we treat everyone with grace plus respect. Plus is our symbol. We're all about providing impartial, unbiased information. So when a phone call comes in through to us, we are going through all of their options and making a recommendation for what is really going to be the best option for that person. It's not always a consumer proposal or bankruptcy, right? We foster individual perspectives and diversity, and we're really working on providing that library of resources to continue that personal growth and understanding. So if you look on our website, we've got tons of blogs, we've got some webinars on there, and we're continually working to build that resource of library. And another resource of library is our partnerships, like we have with Investors Group and some of the other really great businesses that we know share our values. Our vision is to be nationally recognized as the leader for people needing debt help. And like I said, we're in Alberta, BC, and Ontario. And by the end of this week, Saskatchewan as well. So really getting that national presence. And then these are our core values. And I wanted to share that, these are not just printed and kind of put up on the wall and forgotten about. We actually read these out at the beginning of every meeting, and we share stories of how we're actually living these values. So really operating with that highest level of integrity and ethics and honesty in every aspect of what we do. Striving to earn the trust of our stakeholders. Investors Group is one of our stakeholders. So, doing these webinars and whatever else that we can do to really earn your trust is really important to us as one of our core values. Same with developing our long-term relationships based on knowledge and understanding in a caring and sensitive approach. Being adaptable and embracing change. On a dime, we were able to send, majority of our staff to work from home for this pandemic. We've been able to set up video signing, so our clients, regardless of where they are, can sign into the program through our video programs, and also do video counseling with us. So yeah, we do a lot of change in our organization. This is my favorite one, that we recognize and encourage individual responsibility as a means of empowerment. So you're insolvent, but you're not just a victim. We put a lot of responsibility on our clients to empower them to be able to rebuild their worth. And then we're an organization of diversity, diverse cultures and interests and opinions. And what we do is the consumer proposal and bankruptcy, and then we refer out to our reputable partners for credit counseling, debt management, orderly payment of debt, and other education and tools. We have a very unique setup here. So we are almost nationwide, but we just have the one toll-free number. That call comes into our lovely here debt relief specialists. And so our debt relief specialists are kind of our triage, and they're looking to see, okay, based on your situation, do we need to refer you out to a trusted partner, maybe Investors Group? Are we going to recommend the consumer proposal, or are we going to recommend a bankruptcy? And this is where, once we decide, okay, you're going to be working with us, then we're going to set up an appointment in your own city, or right now virtually, of course. And that stay of proceedings is started immediately, so you can start to rebuild your worth and have that relief and hope. And then just a moment to brag, you'll get award-winning service with us. We have been nominated and won the Reader's Choice Award, Diamond winner by the Toronto Star. We are a finalist for the Torch Award with Better Business Bureau, and then rated 3 best in terms of our reviews with 3 best rated. So just a little brag on us, and that's really the end of my presentation. So open to some Q&A now. I'm just going to go to the chat because I know I addressed the RSP one, but there was one other question here, and it says, is there a minimum amount of money owing before a client should consider bankruptcy? That's a really great question. Our rule of thumb is $10,000. But again, whatever is a struggle, if it's a struggle for your client, it's a complimentary phone call to have a consult with us. So generally, I'm going to say 10,000, but for some people, you know, even 6,000 or 7,000 can be a real struggle. And depending on their situation, we may be able to help them out. So if there's any other questions, you can unmute yourself and come on and ask it, or you can share it in the chat.
Taz,
Yes.
how long does the process take, really, from the time of, say, an application for a consumer proposal versus a bankruptcy? What is the turnaround time?
Great question, Joanne. Actually, in terms of, you know, if from the phone call conversation, like from the consultation to actually signing into it, you know, depending on that individual and what openings we have for appointments, it could actually be even on the same day now that we're able to do the video signing, right? So quite often what we find though is, you know, we'll go through the whole process with someone, they're not quite ready to sign yet. And that's where the delay can take place. But once they've signed, they are protected immediately, and it can be as quickly as the same day. And this is why we've started our Ask a Trustee webinars. We're doing these webinars on Tuesdays and Thursdays through the month of May at 7 p.m. I'll make sure that you're included on our invitation, just to help people sort of along that finish line. If insolvency really is the best option for them, we want to get them protected right away. And we're hoping that these webinars will give people the tools to make that decision to actually move forward. So great question. Are seg funds in a non-registered account protected from creditors? As far as I know, non-registered funds are not creditor protected, but let me just double check if there's anything different with the seg funds, Darcy, and I can get back to you on that one. I'll need to check with one of our trustees. Oops. So seg funds. And then we have any thoughts on and process for those having a personal holding company in bankruptcy, and if the directors are personally liable. Really great question. So again, depending on the setup of the business, generally most businesses, even the ones that are incorporated, there is a level of personal liability there. So this question, I'm going to say again, is a little bit specific. It'll really depend on the individual and how their company has been set up. That's a great question to call into our toll-free number and have a conversation around if you're, you know, helping out a client with that, or just kind of being proactive in terms of what you might see. We're definitely seeing more and more, obviously, self-employed people or entrepreneurs, solopreneurs coming to, you know, calling us and wanting that advice, just given the current situation. I think small business has been hit really, really hard. And so quite often, I think we feel like we've set up our business in a way that it's a separate entity. But if you actually look at the lenders are lending to you. It's based on your credit rating. It's based on your history and your standing with that creditor. So great question. I would say that can be very specific given the situation. So call into our amazing debt relief specialist on that one. And I did want to address, Joanne, you and I talked a little bit about inheritances. So I did want to talk about that. You know, if you're helping someone plan for setting up an inheritance for their children, or if you're looking at someone who's, you know, going to be coming into an inheritance. And again, the general rule on that, in a consumer proposal, assets do not vest with the trustee. So if someone is going through a consumer proposal process and they come into an inheritance that they were not aware that they were going to get, it really has no bearing. If they were aware, if they know that someone's getting close and they're going to be coming into an inheritance, you know, we need to have that conversation and just sort of build it into the budget and to the proposal. On the bankruptcy side of things, an inheritance does come into play, and, you know, it can become something that needs to be, you know, disclosed and shared with the creditors. So, you know, again, a little bit more specific depending on the situation, but in general, in a consumer proposal, the inheritance is sort of, you know, a moot point. In general, in a bankruptcy, all the assets vest with the trustee. So if you're aware of the inheritance, or if it comes in during your bankruptcy, it will vest with the trustee. If it happens after the discharge, though, generally speaking, that would not be an issue. So I know it's kind of a vague answer. It's not. It's sort of generally and depends. I know. I'm sorry.
Well, every situation is different for sure. For sure.
Yeah, I know. There's some
Yeah.
things that are just cut and clear, like, you know, what the exemptions are, here they are. And then there are certain things that are very, you know, it'll really depend on that individual and their circumstances for sure.
Yeah, absolutely. Well, thank you very much. Are there any other questions before we go?
I'd love to leave everyone with one last thought, if I may.
Yeah, of course.
Given the current situation, there's a lot of this talk of it's okay to not be okay. And I just want to say, anytime, pandemic or not, recession or not, it is okay to not be okay. We're really, our big goal is to normalize the conversation around debt and really take away that stigma, that shame, the judgment around it. So at Bromwich+Smith, our motto always is, it's okay to not be okay. And we are here to help. So, you know who to reach out to, know who is the trusted professional, and it's okay to not be okay.
Mm-hmm. That's great, Taz. And it was a great interview you had. I think it was with Global, was it?
Yes.
Yeah. So there's some, I'm sure, options for people to actually go and see that interview that you had. So great message, great message. So what I'll do is I'll coordinate your slides with Rebecca, and Rebecca's our regional coordinator. So what she'll do is distribute the slides. So
okay, lovely,
everybody. So thanks again.
Thank you so much for having me. Everybody stay safe, stay healthy, and feel free to contact me or our toll-free number. I'll just put it in here if you have any further questions at all, okay?
Great.
Lovely. Thanks, everyone. I'll just stay on until everyone has logged off, just in case somebody does have one question they want to ask.
Yeah, I'll stick along here with you until the end here as well. So
okay, lovely. Sounds great.
Yeah.
I don't know if Audrey's still on, but thank you, Audrey.
Oh, I didn't see her. Was she on?
Sent me a little private message there.
Oh, nice.
Not on anymore.
Yeah.
Lots of things.
Yeah. That was a great